Hi, everyone. Today's guest is Dave Levine. He's the Associate Dean of Faculty Development at Elon Law. He also is the host of Hearsay Culture podcast and radio. He's an expert in AI, trade secrets law. I'm so excited to chat with you today, Dave. Thanks for coming on the show.
Thank you, Francesca. Wonderful to be here.
So we connected through one of our associates, the amazing Kimber Marie, who those of you watching on LinkedIn probably know her. That's how we connected. She was a rock star 1L and reached out to me with a passion and interest in intellectual property. We wrote an article together and she became an associate this year. And when she found out that we had this podcast, she was like, you need to interview Dave. He's amazing. He's incredible. So thank you for making time today.
Absolutely. I'm a huge fan of Kim Marie's, and I'm thrilled to be here.
So when did you actually start your podcast? Because I know that there's some people in the legal industry who are pro content, some people who are con, but I'm obviously pro, taking the position that I think it's an extension of your personal brand and also helping to break down the barriers between laymen and lawyers. So when did you start your podcast?
Unbelievably, Francesca, I started it almost exactly to the day 19 years ago.
That's
So I
awesome.
Yeah, I started it in May 2006. I was a fellow at Stanford. I had done radio in high school and in college, and Stanford had has a fantastic radio station, KZSU. I was transitioning from teaching, from practice into teaching. I wanted to start reading up more on the burgeoning internet and technology policy issues. That's where I had practiced, and I realized, I'm at Stanford. Everyone and anyone wants to come to Stanford and talk, and there's a radio station across campus. So, make a long story short, 2 weeks after I reached out to them, I was on the air. And podcasting was
Awesome.
starting to explode at that point. And so, about a year after I started it on KZSU, where it still is, I turned it into a podcast.
That's incredible. Okay, so you're the OG.
Yeah, yeah.
That's amazing. Yeah, I think it's obviously, you started 19 years ago. So to anyone who is not sure if lawyers should be on social media, you can watch Dave because not only did you start it, then I think people think, oh, is it too late for podcasts? Are podcasts outdated? I read that it's like the podcasting industry is a multi-trillion-dollar industry. So separate and apart from the revenue, but having the impact and the influence, podcasting is an industry that really isn't going anywhere. So I'm glad you've continued to build it.
Oh yeah, for sure. Because when I started doing it in 2006, it was still kind of a new format. Once people were stuck at home and had other things to do, the podcasting industry exploded. It's hard to argue that it's not, and it's already now increasingly important.
So, Dave, you're obviously at the forefront of this. We're experiencing it in real time. How are you using AI currently in the way that you reach your audience or in the way that you connect with your students or just in general? And how do you think it is affecting society today?
Far as my audience, Hearsay Culture Media, and I do it with Denise Howell, who's a veteran, also an industry veteran. She did This Week in Law on Leah Laporte's network for years, and so she and I do a show together too on the network. We talk about AI a ton for obvious reasons. I've used it a bit. I've used it more from a marketing standpoint than anything else. I teach trademark
Same.
law. So how it is. I don't want to spend my time trying to think through, titles and marketing ideas. It's just not my interest. And so in that area, I have gone to ChatGPT and a few of the other models, and I'm not endorsing any of them in particular, but I mess around with all of them to say, what would be a catchier way to title this particular blog post? Now, I haven't used it for questions. I will say that. I have not used it for questions because, frankly, I think I'm far better at it than ChatGPT is. And also, that's the fun of doing interviews, as I'm sure you know. I like coming up with the questions. I read the materials, and I'm doing it for my own reasons in terms of learning as much as it is for the audience. So I don't use it there. In terms of teaching, It's the Wild West. We don't know, educators, how to use this technology. We really don't. And of course, it's been foisted on society by Sam Altman, more or less, right? Without our choice, by the way, right? I will note. And so now we're dealing with it. So the way I approach it these days is I'm telling my law students, I teach contracts, for example, as your listeners may know if they're lawyers, but if they don't, basic level first year course. And I'm telling my students on May 29, 2025, that if you want to render yourself obsolete, use ChatGPT to write your briefs. Use ChatGPT to summarize facts. Use ChatGPT the way it's pretty good, and it is pretty good at that, because those are the building blocks of what lawyers are paid to do: analyze, nuance, context, not to mention rapport and all the other things that we do in practice. So I am telling my students as first years, don't use it. I recognize, however, that they are going to have to grapple with the technology, and it is efficient if you know how to use it. It is certainly faster than human beings. We know that much. And so much as when I entered practice, which I'm very old now, as Kim and Marie has heard me say repeatedly, I graduated law school almost 30 years ago. So I graduated at the time where we were starting to move away from shepherdizing, which, if your listeners aren't familiar, is the way of figuring out whether a case is still good via books, to Lexis. And I actually learned how to shepherdize in the books, which makes me very old. This is very different. AI is not shepherdizing. AI is creating content. And from that perspective, I think it's a fundamental cataclysmic change. So the way I'm using AI is thinking through about how it should be used, but at least in the first year, I'm not letting students use it. At the upper level, I'm playing around with it a little bit. As far as teaching goes, I'm not using it for teaching. But again, I'm not using it for teaching because I'm better at it. Sorry, Anthropic and Google and OpenAI. And I know they're not trying to compete with me directly, but they are competing. I feel like I can do it my way. As far as the big pictures, look, AI has enormous potential upsides, right? I think about it from an access to justice perspective. I was at Corp Counsel in New York City for a few years. I dealt with pro se litigants, and pro se litigants who do not have lawyers, again, for listeners who aren't familiar, are trying to write complaints, and they don't know what they're doing because they're not lawyers. And to be able to have a platform that can help you format and help you at least say things in a way that a lawyer might understand, I think opens up the courts in ways that we haven't seen before. And there are other ways that AI are used more broadly in decision making that might be helpful. However, for the aforementioned reason that we're not prepared for it, I am much more concerned about the downside risks that I don't think we are accounting for in our profession, nor are we accounting for in the policy arena. To put it directly, we have the second live experiment with AI that has happened based upon reporting from Wired and 404 involving Doge. I mean, Doge has used AI across the federal government in ways that I think are largely lawless. And now we're seeing the results of what happens when we put this technology into the world and where it goes. We need regulation. Now, law maybe not be the answer completely. We need markets. We need norms to act there. But I'm very concerned about the unregulated aspect of how this technology is being developed. The other concern that I have, which is more immediate, has to do with de-skilling, right? And that ties to what I was saying about lawyers, but certainly what I say here. For you and I, Francesca, we graduated law school prior to generative AI, right? We developed the skills necessary to make ourselves sustainable and to sustain the profession. I am concerned, maybe not now, but in a period of time, that it would, in the 10-year window, let's say, or 5 to 10-year window, that if we're not careful, the kinds of things that make lawyering fun, the kinds of things that we enjoy doing as lawyers, could start being replaced by technology, and that would be a tragedy. I don't teach lawyers to become lawyers because it pays my bills, even though it does. I teach lawyers to become lawyers because it's a profession that I love, because the law is a calling, and the rule of law is a foundation of our country and really of our world if we want to live in it. And so I want lawyers to have that same kind of enjoyment. And I don't want technology to take that away from human beings. So those are kinds of the big picture things that I think about.
Yeah, and they're important. And I love how you said that, like, okay, Sam Altman launched it without without really asking anyone whether we should or not, but it's out there, and it's like Pandora's box has now been open. And so we're not just as the owner of a law firm or as a professor or as parents or educators for young children, we're all in these positions of how do we utilize it and how do we train the people who were supervising how to use it. Because we were given the blessing, I think, of not having these tools. So having to truly understand the core concepts in and out. So I can use AI to do some general research, absolutely not case research. But if I plug in, hey, give me an overview of this brand protection strategy for this client, there's all these listings. Like, I've done that before, and it spits it out. It spits out a pretty good answer, but it's absolutely not totally accurate. That's circumstantial. So, but I can tell that because I know, because I am an expert, because I spent so much time. So I think it's going to be interesting that there will be people who think that they can just rely on the technology to really understand. But I think we need to encourage, whether it's students or our employees or staff, to really learn the foundations and master them as the expert. And then we can use AI as tools just to become more efficient, whether it's administrative work or if it is an initial draft of something. But really what I've seen in playing around with it, and we even use, Lexis AI and all the like approved legal AI tools, it's not perfect. You cannot rely on it. And having the underlying knowledge and being able to cross-check is critical, especially when it comes to case research. It's malpracticed, I think, to be using like AI purely for case research, because it will hallucinate cases, and we've seen that in some instances.
Oh yeah, absolutely. And as I mentioned to you before, I did a CLE yesterday for the Connecticut Bar Association, and I pointed it out, and we amplified it. Rule of professional conduct in more or less every state, 1.1 talks about understanding the tools you're using. Right. I mean, it's a fundamental need of lawyering. Now, whether you need to understand it at the computer science level, no, you don't need to understand it. But at this, even today, I'd say not knowing that this technology hallucinates, which again is a euphemism for make stuff up, right? Mm-hmm. Not knowing that, I kind of agree with you that it at this point it's malpractice, and as I'm sure you've noticed, courts are getting increasingly less sympathetic rapidly to the use of it. I think the first few cases that I saw, courts are like, okay, you didn't know. But at this point, after a couple of years, you gotta know. But what I wonder about, of course, is of course, as I was alluding to, is busy lawyers. When I was at Corp Counsel, and even as in private practice, I was with a couple of firms. I mean, I had a lot of cases, and I understand, right? Certainly for a particularly very young, busy attorney, right? You have multiple cases going on, and you can use this engine to, quickly turn around some motion papers or even language in a motion paper. I totally get the need, perhaps even I go so far as to say, to use it when we have overworked attorneys. I hope we can figure out a way in our profession to recognize that those kinds of incentives to use technology, in my view, are the problem of the profession in that sense, not of the technology. As a related issue to me, of course, are the enormous issues with substance abuse in our profession and the ways that people deal with stress, which of course, 30 years ago, we took a course for an hour about these issues, right? Which didn't really get the job done, frankly, right? And so thinking about ways that we can make the profession holistically better for people while still making money and paying the bills and being zealous advocates. These are fundamental challenges. And I feel fortunate as a law professor that I have the time to think about those things.
I would say that I take a very cautiously optimistic view on the technology for a couple of reasons. We are a boutique firm that competes with big law, and to do so, and because it's, building a firm in 2025, I'm looking at the date, May 29, 2025, we have to be lean. We have to be leveraging technology. That's what my whole law firm is built on. Esca Legal is built to leverage technology to be more efficient, effective, and to not burn out our lawyers, because I did come from burnout, and I never want to go back to that, because I do think it's related to a lot of the substantive abuse, is this burnout culture. So if there's a way to integrate the technology legally, ethically, without confidentiality issues, and in a way that sets parameters, and it can actually generate factual information, then fantastic. But I think the point where we're at today, and I give the analogy of going online and going on Google and just asking Google for answers to things and copying and pasting it. You would never do that. No lawyer would ever do that and not think that they're going to get in trouble if they just do that. It's the same thing with the AI. You have to be cross-checking everything. So even if you are using some of the tools that are vetted, that they say they're confidential, that they can help you as a lawyer, absolutely you need a primary source. You need to be checking for everything. So that's like the analogy that I draw, and we're at the inception of it. The technology will probably get better and better, but I think the question is going to be, how do we integrate this in a way that still protects confidentiality and encourages accuracy?
Well, if you want to take away on that point, to anyone listening, recognize that unless you have built your own walled garden large language model, we're putting all that information at risk. Anything you put into ChatGPT, obviously, but all the other ones. And we've seen reports already, right? Even a couple of years ago at this point, Amazon and Samsung were publicly reported as having lawyers basically tell employees, hey, this stuff is spitting back proprietary information as a result of queries. Don't put our proprietary, this wasn't even attorneys, right? These were just employees. Don't put our confidential information into these engines. And that's kind of the low hanging fruit. But otherwise, I mean, I don't know if I'm cautiously optimistic. I'm not pessimistic. I honestly feel at this point, like it's still too early to really tell. I'm not willing to rule out any of the possibilities that currently are posited, the best or the worst. And that's where I think we have to pay close attention.
Dave, and then from an IP perspective, I know that you talk a lot about the intersect between AI and copyright and trade secrets. So can you tell us from a 10,000 view high up perspective on what are some of the biggest legal risks you're seeing when it comes to AI and intellectual property, and what are some of the main takeaways from the biggest cases that have been released in the past couple of years?
Yeah. Well, I mean, one of them is what, as far as trade secrets goes, what I just mentioned, right? I mean, that's the lowest hanging fruit, which is we are seeing these engines more or less defeat trade secrecy because they have been used in ways that don't meet the reasonable effort standard within the law. And again, courts are still, kind of figuring out, whether it's reasonable to use it and how to use it, but it's still very risky. So that's one.
Can you explain that to someone who doesn't know what a trade secret is, or why putting information into ChatGPT or a public model could have you lose trade secret protection? Can you explain that?
Sure. In a nutshell, one of the elements of having a trade secret is that you use reasonable efforts to maintain the secret. And that's a contextual area. But the question becomes, is it reasonable to put trade secret information into an engine that itself, right, is not under your control, that has terms of service which might be murky, and where there is evidence that it could be shared with others? And so, you could make an argument that it's reasonable, but you're going to have an uphill climb if, as has started to happen, that information goes into an engine and comes out somewhere else that is out of your control. And so it becomes a very dangerous tool of trade secret misappropriation. So that's one big area where that, and it's starting to happen. We're also seeing it on the other side in the New York Times, the OpenAI case a couple of weeks ago. The court ordered OpenAI to more or less, to avoid spoliation of evidence, to retain all data. Right, all data with regard to the litigation, which presumably would include anything that anyone using ChatGPT has put in. right? And so the potential is that your information, which is proprietary, could be produced in discovery in this litigation. That's not a situation you want to be in. So in terms of the trade secret issues, I'm talking about the lowest hanging fruit issues, that's certainly front and center. As I've alluded to to answer your previous question with regard to IP, on the copyright side of things, of course, we've seen, multiple lawsuits, and, New York Times v. OpenAI is the primary one, where now we're dealing with questions of how these engines are developed, what data they use, and whether they're fair use and so forth under copyright law. I think ultimately there's a strong argument that they are fair use, although I also think maybe they're fair, which is not the law. The fair use factors don't account for this kind of technology as well as I think they might, and that's something I'm looking at. It's interesting, even on the trademark side of things, in your area, right? These video and graphical engines that are being developed, I don't know that they raise trademark infringement issues, although they theoretically could, as much as they change, as we already alluded to, the nature of marketing. It is very easy now to come up with a really wild graphic for your product, right? You need a widget, you need something else, you can do it. And of course, this week, right, Google launched another video creator, which has already been, you've seen that, which has already been used in all kinds of crazy ways. So, I think trademark practice is, I think, and you'd be able to answer this question or assess this better than I can, is going to change pretty quickly as it becomes easier to become a marketer or a graphic designer or even, right, an ad person. And then, since we're talking about IP, on the patent side of things, here's what I think is the most interesting issue, which is whether anything is ever going to be non-obvious again. If you have,
wild. Yeah.
Yeah. So there's a lot. I know we're short on time, but there's all of these great issues. And I would encourage your listeners, aside from obviously, shameless self-promotion, listen to Hearsay Culture radio at hearsayculture.com and listen to yours. Dig in on these issues, because the cool thing about this, aside from day-to-day practice, is that they are a lot of pretty new issues that really haven't come up before. And it's kind of amazing to be in 2025 to have new questions of law arising. So that's kind of interesting.
It really is. And especially like taking the traditional blocks that were given and reorganizing them and using the existing legal frameworks and tools and applying them into new mediums. It's fascinating. What gives me confidence in this area is that we are experts in the law, and our job is to apply the law to the specific facts. And so we've seen it where the DMCA, the Digital Millennium Copyright Act, was created out of a need for some newer tools. It's possible that we're going to see some new tools be released and some legal tools to combat intellectual property violations, or also to protect intellectual property in this medium. But I think overall, from where we are today, using the same tools that we're given, we have to apply them to the new set of facts, and doing so isn't wildly complicated. Now, that's probably a gross understatement given the millions and millions of dollars that are being spent to litigate some of these high-profile cases. But in my perspective, I think we are still doing things very similar to the old way. So for example, if a client is going to be using AI to create ad campaigns, just as we would do with a traditional ad campaign, we are doing the same assessment for trademark infringement, for copyright infringement, or for right of publicity rights. Yeah. So we had this instance where there was an AI generated campaign. So we didn't need clearance from the people because all the people were fake. We didn't need clearance for copyrights because they were using generated. However, when you look into it, some of those assets that were created were either identical to pre-existing works or too close, where we'd had to go back and tell the AI we go back and tell the client to work with the ad agency to change that copy. There was also a situation where they took a branded product that was an identical branded product. So it was infringing not just the logo that it the AI thought that it was unprotectable logo. It was a protectable trademark logo, and it infringed the trade dress, which was the shape of the product. So having lawyers review your ad and marketing materials, even though they're using AI, is actually even more important. And having strong contracts with the people that you're hiring to do these deals with, and having the right indemnity provisions is critical. So I think like we're still applying the same laws into these new mediums. And if anything, we are going to need really, really good lawyers to continue to advise clients in this area.
Yeah, I think, and that's where I think, to me, the trademark issues, I agree with you. The trademark issues are, I was alluding to, are more or less, there could be infringement and you do the same kind of analysis. It's where you get into these other kind of, information generating questions that I think things become really interesting and very challenging, but exciting.
Yeah, right. We have to, it's here, we don't have a choice, but it's about how to proceed and build and create in a low risk way and try to avoid lawsuits from a client perspective. And then from our perspective, leading teams and educating the new generation how to use it in a way that isn't going to destroy their ability to learn skills, but also help them. So it's fascinating. And I really appreciate you taking the time, Dave, to come on the show. Where's the best place that people can connect with you?
So for Hearsay Culture, go to hearsayculture.com, and we're on all the major platforms. If people want to shoot me an email me at dave@hearsayculture.com.
Thank you so much. Thanks, everyone. We'll see you next week.
Thank you, Francesca.
Bye.